If you own real estate in California and all you have is a will, your estate plan is incomplete. I'm Jayson Elliott. I'm a California attorney at Bay Legal, and I've spent years helping real estate investors, medical professionals, and others protect what they've built. So last week, I told you I'd show you why most California property owners have the wrong answers on wills and trust. If you own real estate in California and all you have is a will, your estate plan is incomplete. A will not take care of that real estate the way you think it will. And it may cost your family far more than you think. Today, will versus trust. What each does, what each one can't do, and how to know which one is right for you. The most common thing I hear from new clients, I already have a will, so I'm good. I already have a will, so everything's covered. I understand why most people think that. A will feels complete. It says who gets what. But here's what it actually does. It tells a probate court judge what you want, and then the court does the rest. A will does not transfer the property. The court does that. A will does not keep your estate private. Everything is filed in public record. And a will does not spare your family from a court process that can take anywhere from 12 to 18 months and cost tens of thousands of dollars. A will is an instrument. It's not a solution. Every dollar comes out of what your family receives from the estate, and every dollar is completely avoidable. California probate fees are set by the statute, calculated as a percentage of the gross value of the estate, not the net value, gross value. Before mortgages, before debts, before anything is paid off. On a $1 million estate, statutory attorney fees are approximately $23,000. Statutory executor fees are another $23,000. That's $46,000 before court costs, before anything else. A modest California home today is worth well over $1 million. On a $2 million estate, those fees can exceed $90,000. Every dollar comes out of what your family receives from the estate, and every dollar is completely avoidable. Your assets, your beneficiaries, your wishes are all private. A revocable living trust is a legal entity you create during your lifetime. You're the grantor or trustor. You're the trustee. You manage the assets exactly as you do today. It's a revocable trust because you can change it over time. You can add people, change people, delete people, add more assets. It's yours to control. You transfer assets into the trust. For real property or real estate, the title is updated. It's retitled in the name of the trust, and a new deed is recorded. For financial accounts, your brokerage accounts, your 401k, your checking and savings accounts, you've got a couple options. You can update the name on the account to the trust, or you can add the trust as the beneficiary. So when you pass, all the assets from those accounts go into the trust, or the accounts themselves go into the trust. While you're alive and capable, nothing changes. Nothing changes about how you use or control those assets or those accounts. When you die or become incapacitated, your successor trustee, somebody who you select to oversee your estate, steps in immediately. There's no court, so there's no public records. There's no judge, so you don't have to spend 12 to 18 months in court, and no $90,000 or $300,000 fees, no 18 months of waiting. It stays private. A will becomes public record the moment it enters probate. A trust is never filed with any court. The only thing filed is the new deed at the time you set up the trust and transfer the property. Your assets, your beneficiaries, your wishes are all private. I see the consequences of missed Property 19 planning every single week. This is very California specific, but Prop 19 took effect in 2021. It dramatically changed the parent-child property tax exclusions in California. Before Prop 19, a parent could transfer any real estate to their child, and the child kept the parent's low assessed value. Under Proposition 19, most non-primary residence transfers trigger a full reassessment to current market value now. Here's what that means in reality. Rental property bought in 1988 for $180,000 at the time. Today it has a market value of $2.4 million. Your property tax bill as the original purchaser of that property is somewhere around $2,200 a year. When your child inherits without the right trust structure, their property tax bill is going to jump to $28,000 or more per year on a permanent basis. The right trust structure can minimize that exposure, but you cannot fix it after the fact. The planning has to happen before the transfer, before the incapacitation, before the death. Most California adults need both a revocable living trust and a will. Let's answer the question directly. If you own real estate property in California, a home, a rental, any real estate, you almost certainly need a revocable living trust. Even my wealthiest clients started with a revocable living trust. If you have children, you need a will regardless of whether you have a trust. A trust cannot name guardians for your children. Only a will can do that. If you have property in multiple states, a trust avoids ancillary probate. Without a trust, your family may open a separate probate in every state where the property is owned. The short version, most California adults with meaningful assets need both a revocable living trust and a will. The will is the safety net, catching everything not already in the trust. But a will alone is almost never the complete answer in California. A trust that owns nothing does nothing. The most common mistake among people who already have a trust, they created it, they notarized the documents, they paid the attorney, and then they never transferred their residence into the trust. This is called the funding. We have to fund the trust with something. Generally, the primary residence is the first thing we fund the trust with. The trust exists on paper, but it owns nothing, then the trust is worth nothing. And a trust that owns nothing does nothing. When the person dies, the trustor, the person who created the trust, their estate goes into probate anyways because the trust doesn't own the house, because the asset was never retitled. This is called an unfunded trust. It's far more common than you would expect. If you have a trust and you're not certain that that property or any California real estate is titled in the name of the trust, please verify that before you do anything else. If you own California real estate and you're not certain your estate plan is structured correctly, that is exactly what we do here at Bay Legal. I put together a free California trust and funding checklist, step by step. Make sure your assets are actually in your trust. It's linked below. If you want to talk through your specific situation, we're here. Next week, I'm going to go over powers of attorneys and healthcare directives, the two documents most people forget entirely, and what happens to your assets and your medical decisions if you become incapacitated before you die. Subscribe so you don't miss it, and I'll see you on the next one.